Hello friends, I am Advocate Sulbha and I welcome you all to my channel. Friends, today I am going to talk on a divorce petition filed by a husband against his wife in the year 2007. They were married in the year 1987 and a son was born to them in the year 1990. Thereafter, the wife quit her medical practice and chose to become a homemaker. The husband got involved with a lady in the hospital who was the HR and admin of the hospital. The wife started getting suspicious and there started fights and bickerings between the husband and wife. The fights reached to such an extent that the husband filed the petition for divorce against the wife on the grounds of cruelty under the Hindu Marriage Act. The wife filed her written statement to the petition filed by the husband. She stated therein that her husband was moving about and having an affair with the HR of the hospital and that he was also going to tours with her not only in the country but also abroad. She further stated that she was introduced as his wife by the husband. The petition went on and in the year 2017, that is after a period of 10 years, the petition was on the stage of cross of the husband. In the cross, the husband admitted of having contracted a second marriage with the lady. He also produced the marriage certificate of his second marriage with the lady. He also admitted to having a son out of the said marriage and produced the birth certificate of the son. After getting knowledge of these facts, the wife sought to amend her written statement and prayed to the court by way of application for seeking amendments to her written statement, vide para 35, 36 and 37. In the para 35 and 36, the wife stated that the husband was having an illicit and illegal relation with the wife and that she was still the legally wedded wife of her husband and that there was no divorce decree passed by the family court. She further stated that the husband had played fraud on her and therefore there was no limitation and she wanted to file a counter claim against the husband seeking declaration that the marriage which was solemnized between the husband and his second wife be declared null, void and illegal, that the second wife be declared not to be the legally wedded wife of the husband, and also that the son begot from the second marriage be declared to be the illegitimate child of the husband. The family court has allowed the amendment application partially only to the extent of the paras 35 and 36 of the proposed amendment, but it has not allowed the counter claim which was sought by the wife. Being aggrieved by the order of the family court, the wife filed a writ petition in the High Court. The husband also filed a writ petition against the order passed by the family court, partially allowing the amendment application filed by the wife. The High Court, after hearing the rival petition, has allowed the writ petition filed by the husband and it has dismissed the writ petition filed by the wife. It has stated that the amendment is at a very belated stage which cannot be allowed. At the same time, it has given liberty to the wife to file a fresh suit or proceeding against the husband for seeking whatever declarations she sought therein. Being aggrieved by the order passed by the High Court, the wife has approached the Honorable Supreme Court. In the Supreme Court, the advocate representing the wife has stated that it was only for the first time in the year 2017 that the wife got knowledge of the second marriage contracted by the husband. Also, she for the first time came to have knowledge of the son begotten from the marriage. So she was very much entitled to raise a counterclaim against the husband. But this was strongly opposed by the advocate of the husband. He stated that in the proceedings in the lower court, that is in the family court, the wife had admitted that she had knowledge of the second marriage solemnized by her husband in the year 2007, and that she had made an application for seeking the marriage certificate and had obtained the marriage certificate of the second marriage solemnized by her husband. Therefore, these facts were not brought forth by her at that relevant time, and now in the year 2017, this application is made by the wife simply for prolonging the proceedings. So it was strongly opposed by the husband. After going through the rival contentions of both the parties, the Supreme Court has stated that it is true that a spouse can raise or can file a counter claim against the other spouse in a petition filed by one of the spouses. But for that purpose, the allegations or counter claims or the contentions raised in the counter claims need to be against the husband or the wife, whoever it is, and not against the third party. Like for example, in the given case, when the husband the wife can raise contentions only against the husband and cannot raise a counter claim to the effect that the second wife be declared as not being the legally wedded wife of the husband. The third parties, there cannot be a counter claim against the third parties. But at the same time, the Supreme Court has held that if the wife seeks declaration, then she is at liberty to file a fresh suit or proceeding against the husband. So in a way, the Supreme Court has reiterated the order passed by the lower family court. Friends, without making it more complicated, at this juncture, I need to tell you that whatever papers, documents, proceedings or facts which are in your possession needs to be brought forth before the court if you feel that they are substantial in deciding the case filed by or against you. I thank you for watching this video of mine, and on a concluding note, I would very much appreciate if you like, share and subscribe to my channel. At the same time, I would really like if you give your valuable suggestions and comments to this video of mine. Till then, bye.